This is Wills and Trusts, Chapter 3, Part 3, which includes the components of wills and contracts relating to wills. So we will begin by reviewing the components of a will and beginning with integration. In your textbook, integration is discussed within the context of a case, In re Estate of Rigsby, found on page 241 of your textbook. Integration of wills defines what pieces of paper make up a will. All papers present at the time of the execution and that were intended to be part of the will are integrated into the will. In the present case, at issue was whether the testator's holographic will, which spanned 2 pages that are reproduced on pages 242 to 243 of your textbook, were part of the will, or if it was just the first page. Now, when you take a look at page 242 and 243 of your textbook, you'll see that both pages were entirely handwritten, and each page was initialed and dated at the top. The first page began with the words, "Insomuch as I do not have a will, I would like to make the following arrangements in the event of my death." The second page listed items that were supposed to go to specific individuals, and it was found folded with the first page. They were folded together. Now, the pages weren't fastened with a paper clip or a stapler, and the testator only signed the first page. And underneath the testator's signature, there was a blank space. Nowhere in the first page was there reference to the second page. And there were also no references to the items in the second page. So the court ruled that the first page would be admitted into probate, but the second page was likely just a draft page that was used to brainstorm the first will. So it was excluded. This case demonstrates that in the court's effort to determine what pages should be integrated into the will, they look to the intent of the testator to see if the testator appears to have intended that they be included. And they look to a variety of facts, as you can see in this case. Now, as we previously discussed, codicils can modify existing wills, but they also republish that will as of the date of the codicil. So, for example, if a will was executed in 2015, and then in 2016, the codicil was executed, then the will is republished at the date that the codicil is published or executed. This is called the republication by codicil. This can become very useful when there are defects in the execution of the previous will. So, for example, if in the 2015 will, there was only a signature for one witness, but in the 2016 codicil, there were 2 witnesses and it was properly executed, then the defects in the execution for the 2015 will become cured. In determining the components of a will, we can also look to incorporation by reference. And if you take a look at page 245 of your textbook, you'll find UPC 2-510 from the 1990 revision. And it spells out how a writing can be incorporated by reference. Any writing in existence when the will is executed may be incorporated by reference. So there is the requirement that the writing be in existence at the time the will is executed. If the writing is created after the will is executed, then this element will not have been met. All right, so the writing needs to be in existence when the will is executed. It can be incorporated then by reference if the language of the will demonstrates this intent, and then describes the writing in sufficient detail that would permit a court to be able to identify it. So, in sum, the writing must be in existence at the time that the will is executed. The will must demonstrate the intent to incorporate, and the will must incorporate or must describe the writing sufficiently to be able to permit its identification. Now let's take a look at a case, Clark v. Greenhug, in your textbook on page 245. The testator, whose name was Helen Smith, executed a will in 1977 and named her cousin Frederick Greenhalgh as the executor of her estate and the principal beneficiary. Her will provided that Greenhalgh would receive all of her personal property other than certain items that she designated by, quote, a memorandum left by the testator and known to Greenhalgh, or in accordance with the testator's known wishes, end quote. Before executing this will, the testator had in 1972 prepared a memorandum for disposal of her personal property. In 1976, Naismith modified the memorandum with interlineations or lines through it, additions and deletions. But neither edition of the list mentioned the farm painting involved in this case. This case highlights a UPC exception. Typically, if an entry is made after the publication of a codicil, then the entry should not be given effect. But there is an exception under the UPC for the disposition of tangible property. And if you turn to page 252 of your textbook, you'll find UPC 2-513, which is in the 1990 version of the will, of the UPC. And what it states is that whether or not the provisions relating to a holographic will apply, so whether or not it's a holographic will or a written will, a will can refer to a written statement or a list to dispose of items or tangible property. To be admissible, that list must be signed by the testator and must describe the items and the devisees with reasonable certainty. So the devisees are the beneficiaries. The writing may be referred to as one to be in existence at the time of the testator's death. So it doesn't necessarily have to be in existence at the time that the will itself is created. It may be prepared, it may be altered by the testator after it's prepared, and it may be a writing that has no significance apart from its effects on the disposition made by the will. So had the court found evidence of an entry into a memorandum in the Clark v. Greenhalgh case about that farm picture, then that may have been sufficient to actually award that farm picture that was at issue to Jenny Clark, who was claiming it. They didn't find that evidence. All right. Now, another way that a will may dispose of property is by reference to an act of independent significance. If you take a look at page 254 of your textbook, you will find UPC 2-512, and it is version 1990. And it states that a will may dispose of a property by reference to an act or event that have significance apart from their effect on the dispositions that are made. So if a testator, for example, were to devise $500 to each of the full-time employees of the testator's company at the testator's death, that would be an example of an act of independent significance. Because whether or not somebody is a full-time employee is an act that has independent significance from the testator's will. So hiring and firing, it has significant lifetime consequences that are unlikely, unmotivated. They're not likely motivated by estate planning. And this is part of an essential part of the doctrine of the acts of independent significance. Now, I'm actually not going to say too much about contracts relating to wills. I do want to point out that this section discusses two types of contracts. The first are contracts to make a will, and the second are contracts not to revoke a will. Even if a will does not comply with the conditions of a contract, that will still can be probated. The person who is the injured party under the contract can still sue for damages or restitution under contract law, but not at the probate court. So to the extent that contract law is applied, we don't have to worry about it for this class. And so if you take a look at the case on page 258, Keith v. Lulofs, this is an example of what are called mirror image wills, and they're pretty common. It's when a husband and wife design their wills to be mirror images of each other. Now, mirror image rules in and of themselves do not give rise to a presumption that a contract exists. Just because wills are a mirror image doesn't mean that they were created in a kind of quid pro quo fashion. So the elements of a contract still have to be met in order to find a contract relating to wills. You know, the whole offer acceptance consideration bit. So just the presence of a mirror image will is not enough. And that's all I'm going to say about contracts relating to wills. And with that, we conclude this video and chapter 3.